come to the final case on today's docket, Martin versus State.
Thank you, Your Honor. Good morning. My name is Don McCray, and I, along with co-counsel Elizabeth Salerno, represent the appellant Arthur Martin. This is an appeal of the Circuit Court's denial of Mr. Martin's initial Rule 3.851 motion for post-conviction relief. I'd like to start off today's argument by focusing on Issue 1 of our brief, the ineffective assistance of counsel at the guilt phase of Mr. Martin's capital trial. This is a case where the evidence at trial against Mr. Martin consisted solely of eyewitness identification and testimony by the co-defendant, two of the most problematic and least reliable forms of evidence. Counsel's defense at trial was one of misidentification, and reasonable counsel would have presented evidence to support their chosen defense. However, that was not done in this case. Trial counsel failed to impeach the state's witnesses on cross-examination. He failed to call witnesses to support a misidentification defense, and he failed to challenge the photo lineups which identified Mr. Martin as the shooter. So I'll start with the failure to impeach. Cross-examination is probably the most important tool in a defense attorney's toolbox. And in this case, trial counsel had statements made prior to trial that were inconsistent that he failed to use to impeach these witnesses on key issues such as the identification of the shooter. Now, the trial court made sort of an aggregate finding as to the failure to impeach, saying that counsel made reasonable decisions based on his strategy to, quote, keep bad information out. However, this was not based upon competent substantial evidence. For example, Sebastian Lucas was one of the witnesses who testified at trial. He testified that he saw the shooting and that and then he identified Mr. Martin as the shooter. However, he had made different statements previously before trial. The first time he spoke with police, he said that he didn't see anything. He didn't see the shooting, he didn't see the shooter. He only heard it. The next time he spoke with police.
How is that ultimately prejudicial, though, if Mr. Lucas gave probably the most detailed of all the eyewitness testimony about what he saw, what happened, and that statement was consistent with what he saw 6 days after the incident? So even if there was that initial statement of I didn't see anything, 6 days later, as I understand it, he came back, gave a detailed statement, and that statement was largely consistent throughout, including in trial testimony. How is that prejudicial if the testimony that came in was so detailed, and went so much to the premeditation element, if the single question is, didn't you make a prior statement when you first got there that you didn't see anything, and then 6 days later said that you did?
Well, I think that's problematic because there's also another statement that he made in his deposition that in between the first and the second statements to police, he had engaged in neighborhood gossip. So he had spoken to people at the apartment complex about what happened in the shooting, and he had gained some of his information from those people.
But that wasn't true 6 days later. The deposition happened, as I understand it, some years later from the incident. Is that fair?
Yes.
So 6 days later, he gives a very detailed statement that appears to not be tainted in any particular way. And certainly it's not surprising that given I think it was his sister-in-law or his sister-in-law who he was with at the time, who saw the same shooting and also was an eyewitness to what had happened, that they would have had information identical or similar to each other, correct?
Possibly.
Right, but so I'm having hard trying to see what the prejudice would be, even if counsel for some reason didn't original statement the original day of I didn't see anything, and 6 days later gives a detailed statement that's largely consistent throughout. That doesn't appear to be affected by hearsay.
But in between the first time he said, when he first spoke to police and he said I didn't see anything, and then again when he spoke to the police and said I saw the shooting and identified Mr. Martin, in between those two times is when he engaged in the neighborhood gossip. So before he gave that detailed statement, that is when he had been speaking with other people at the apartment complex about the shooting, if that makes that more clear. So that's
I understand. I'm still having a hard time understanding the prejudice, given that his testimony at trial ultimately wasn't impeached in any way, given how detailed it was, and it was corroborated by just about everybody else in terms of what they largely saw happened.
Well, I think the problem is that there was impeachment material out there as to what happened, as to all of the witnesses, and trial counsel failed to impeach any of them. And so, kind of like you're saying, it did strengthen all of the witnesses' testimony because none of them were impeached. So for Sebastian Lucas, though, I think it's problematic because counsel could have given jurors a reason not to believe his testimony and not to believe his identification of Martin as the shooter. If he had said, you originally told police you didn't see anything, and then part of what you learned was from the neighborhood, that could have called into question the credibility of his testimony, and he could have given jurors some reason to disbelieve him and disbelieve that Mr. Martin was the shooter, since his defense at trial was one of misidentification. So I believe that could have aided his argument in that. You mentioned Lauren Burns. She testified at trial that she was on the steps with Sebastian Lucas and her small children. She saw the shooting, and she also identified Mr. Martin as the shooter. But another thing she said was that the first time she had ever seen the shooter was the day of the shooting. However, she had previously made an inconsistent statement about this. And this is important because it goes to the identity of the shooter.
But didn't trial counsel explain that as a matter of strategy, he didn't want to delve in that because how they knew each other was through what I'll call unsavory means?
Well, she stated that she knew the shooter previously because he had tried to flirt with her, and she wasn't interested because he was a drug user. So I believe that was one of his justifications for not impeaching him.
That's what I'm referring to.
Right. Well, the problem with that is that there was information that came out about the use of drugs in this case. And I know at the evidentiary hearing he stated that he didn't want any mention of drugs coming in, especially as it related to Mr. Martin. The problem with that is he knew ahead of time that that sort of information was coming in. Another witness even testified that the apartment complex, that's why people go there, people sell drugs there. And it's not really much of a leap to assume that's why everyone was there that day. So having known that.
But counsel, I guess the question is how under Strickland, which gives a lot of deference to strategic decisions, can we say that no reasonable counsel in a similar position would not have made the decision that trial counsel did here to say, you know what, let's avoid the topic of my client's drug use because that makes my client look a lot worse than he otherwise will?
Because I think reasonable counsel would have known that that information was out there and probably going to come in at trial and would have done a motion in limine to protect or to prevent that information from coming in. But
counsel couldn't have prevented that from coming in if he had delved into the inconsistency, because the state would have come back and have been very likely to say, no, we do know him and here's how I knew him and I'm not sure why I said that originally.
Or
Maybe because I was embarrassed.
He could have voir-dired on it. There are so many other things that reasonable counsel could have done.
Didn't counsel answer that too on the voir dire? Didn't counsel say, you know what, I really didn't want to bring up the issue of drug use for my client, even in voir dire, because it would make my client look a lot worse. I'm trying to save the guy's life.
Yes, well, and I think the reason that I'm saying that's not reasonable is because his defense was misidentification. So he's prioritizing someone finding out that he may be a drug user versus this isn't him, he's not the shooter. And that would have, this impeachment would have called into question whether she actually identified the right person and whether her identification was credible. So that was the most important thing, and that's why I'm arguing that reasonable counsel would not have prioritized the client being a drug user over.
But a reasonable counsel has to balance all sorts of things. It's not like you just establish some kind of absolute priority. You've got to weigh how is this going to play, what the jury hears, how's it in the guilt phase, how's it going to play in a potential penalty phase if that comes. And it seems like you really do want to second guess that.
No,
I
Your
guess
Honor,
that's what 3851's about there.
Right, I understand what you're saying, Your Honor, but I guess what I'm trying to say is her testimony went unrefuted and unchallenged, and this was a way that he could have challenged it. This is a way that he could have argued in closing, this witness should not be believed. She's made a prior inconsistent statement. Because he didn't do that, because he prioritized the drug usage over it, her testimony went unimpeached and unrefuted. So that's why I'm saying that was prejudicial, and reasonable counsel would have impeached her with that statement. There were also witnesses that trial counsel failed to call that he could have called to testify at trial.
Can I go back to that? You've stated a few times now that he didn't impeach anything here, but at least with regard to Ms. Burns, he did impeach as to some deposition testimony, didn't he?
As to Ms. Burns?
Yeah, I'll be specific.
I don't
Did
recall.
counsel ask specifically if she had made a prior statement about whether she could positively identify the shooter?
Yes, Your Honor.
He did use that, didn't he? In other words, he made the kind of reasonable choice that Chief Justice Kennedy was just talking about. There are certain things he could impeach on and certain things he didn't, and he tried to avoid certain areas and focus on other areas, right?
So you're talking about when he asked, I just want to make sure I'm talking about the right thing, when he said that you picked him out because he looked familiar? Is that what you said?
I'm referring to page 324 of the transcript, where Mr. Shea referenced, trial counsel referenced the deposition testimony where she stated she wasn't sure she could positively identify the shooter if she were to see him again because it had been a while. She had made that statement in a prior statement there. And I guess what I'm saying is, it wasn't like there was no cross-examination. The trial counsel didn't sit on his hands throughout the trial. He did stuff, he just made choices, right?
I agree that he got up and asked questions, but I don't think he used any of the information about prior inconsistent statements that could have impeached these witnesses, and I think that was important. So that is something that's in the jury, the instructions that the jury gets about whether prior inconsistent statements have been made. And
The jury did get that here. The jury did get that here.
They did.
And there were some prior inconsistent statements that had been asked about, right?
There was some discussion in the charging conference about whether the judge was going to give that instruction. And they were going through the list, and the judge said, well, this one, I'm not sure we got there. I don't think you got, basically, you didn't, and you didn't bring out any prior inconsistent statements. And trial counsel agreed and said, yes, I agree. So initially it appeared as though that wasn't coming in, but then if you look, the judge actually did include that. So, so there was some discussion about whether he had impeached witnesses. And going back to his failure to call the witnesses at trial, there were two witnesses that could have been called to support his misidentification defense, Willie McGowan and Larry Jones.
So we're talking about Mr. Jones for a second. So with regard to Mr. Jones, how do we get around the trial court's finding here that his affidavit, because the testimony that you're saying is he would have said based on his affidavit that he could not have identified, but that wasn't what his testimony was. His testimony was that there was a description of the shooter that was actually consistent with Mr. Martin, although he said, I didn't see the person and cannot identify them. Wasn't that Mr. Jones?
I think that's a little mixed up. So
from supplemental police report number 6.
Yes.
Wasn't that Mr. Jones's testimony that I just described?
So he told one police officer that he saw the side of the face, and that
But that he could not identify him.
But he didn't think he could identify him. Yes,
Right.
Yes, Your Honor.
And the trial court credited that testimony over the testimony of the affidavit, right?
Yes.
How do we get around that?
Well, she didn't just look at that one part of the police report. She also looked at the fact that there were different. So he initially spoke to one officer, and in his affidavit, he said he only spoke to one detective, and that description was consistent with what he said in the affidavit. It was the shooter was black male, early 20s, approximately 160 pounds, 5'8". But then there's another in a different supplement where another officer says that he spoke to Jones and McGowan together, and that Jones gave the description of a short, fat black male. I don't think that's...
Which was the consistent description of Mr. Martin throughout.
That's correct. That's correct. But that was right also with the same description, or with the description given by Willie McGowan. And Willie McGowan did say it was a short, fat black male. But in Larry Jones' affidavit, he was shown that, and he said, I never gave that statement.
And I understand that. But I guess we have to take the trial court's order as it stands, as long as it's supported by competent, substantial evidence. And as I understand it, the detective did testify, no, this is the statement that was made to me, and the trial court credited that over the version that's in the affidavit. Isn't there competent, substantial evidence supporting that?
I think it's reasonable, given the number, if you look in the police reports, and you clearly have, the number of police officers that were on the scene that day, coupled with the number of people they were interviewing that day. There were multiple people they were interviewing at the apartment complex. I think it's reasonable that the second statement that they credited to Larry Jones was just a police error. And the officer testifying as to, no, he really told me that. This is an officer looking at it years later. But I think at the time of trial, had trial counsel actually spoken with Larry Jones could have clarified that and said, no, I never gave that second statement. And so just to speak a little bit more about Larry Jones, for the first time let me just go back. So Larry Jones was riding his bike past the apartments when the shooting occurred. And that's how he witnessed the shooter and gave a description. For the first time at the evidentiary hearing, trial counsel stated that he had called Larry Jones on the phone and decided he couldn't be of any help to the defense. And in part denying this claim, the trial court gave deference to that justification. However, the statement by Mr. Shea, trial counsel, was not credible, and it's refuted by the record and should not be given any deference, and I'll tell you why. Trial counsel was deposed prior to the evidentiary hearing, and he was very clearly asked whether he ever spoke to any witnesses, either while he was physically at the crime scene or at any other time outside of a deposition, and he said no. So at the evidentiary hearing, when I impeached him with that, he tried to claim that he didn't understand the question.
Well, what he said was, didn't he say it was in the context of speaking to people at the scene? Didn't he say that?
But that's what he tried to say, but that's not what the question was in the deposition. It was very clear, and he said multiple times that—
Isn't the trial court, when someone's faced with impeachment and is explained, which is how the procedure is supposed to go, the trial court's allowed to make credibility findings regarding that, isn't it?
They are. But I would also point to a few other things that discredit his testimony. So later on in his testimony, he claimed that it was not his practice to ever interview witnesses without the presence of the state attorney. So that undercuts his assertion that he called this witness on the phone. Furthermore, we submitted as evidence his timesheets that were submitted to JAC for payment on the case under penalty of perjury as to their accuracy. And nowhere in those very detailed timesheets does it say anything.
Do you have a case where this court overrode a trial judge's credibility determination, the person that's the finder of fact, that's in the courtroom, that's listening to the testimony, hearing the cross-examination, looking at the witness as the witness testified, and you're making the same arguments, they make a credibility determination, and then we come up here and say, well, you know what? We think the trial judge who was in the courtroom was wrong because of all these factors that were argued as to why he should not be credited, the witness should not be credited. Do you have any case where this court has done that?
I do not. I do not that I've come across, Your Honor. But
because it's not our job to reweigh and determine credibility, correct?
But it is your job to look at whether the findings of the trial court were based upon competent, substantial evidence.
And isn't testimony from a witness, whether you think it should be believed and was properly cross-examined or not, isn't that going to be competent and substantial evidence?
I don't believe the trial court considered all the things I'm telling Your Honor as to why it should not be considered. She didn't make a finding as to all of these things and whether she disbelieved our argument or whether she simply just gave him—
Counsel, you have consumed more than half of the time you had set aside for
I have, Your Honor.
rebuttal, so
Thank you.
you can keep going, but the time is going.
Would you like for me to finish answering yours? Okay, I'll reserve the rest of my time for rebuttal. Thank you, Your Honor.
May it please the court, my name is Lisa Hopkins and I'm appearing on behalf of the state in this matter. Francis Shea, the trial counsel, testified during his evidentiary hearing that his client admitted to him that he was in fact the shooter on October 28, 2009, and he was the one who shot Javon Daniels. Based on those conversations, which were confirmed by Mr. Anderson, who was co-counsel, Mr. Shea made the decision to approach the trial and attack identification and also premeditation. This is a completely reasonable strategy in light of the evidence that was presented, what the witnesses were saying, including the co-defendant, Mr. Franklin Beatty, who testified that Mr. Martin took his .45 caliber Masterpiece ACP gun from him, went over to the victim's wife, proceeded to shoot him 9 times from the driver's side, walked around, shot one time towards the top part of the windshield, and then shot three times.
You would concede that the record reflects some pretty obvious cross-examination for the eyewitnesses that could have been done, correct?
Yes.
And once you say that, my only defense is misidentification, what's the justification generally for not doing obvious cross-examination that's available from prior inconsistent statements, for example, when declaring that that's my defense and yet?
Well, to start with Mr. Lucas, Mr. Lucas was a little inconsistent about the facial hair that was on the shooter.
But counsel, that's not what your co-counsel said, or your opposing counsel said, and that's not what was the focus on. There was that issue at the trial court level, but that's not what we're talking about here. The real statement is Mr. Lucas originally said when interviewed by police that he did not see the shooter, and 6 days later he said he did.
No.
How is that not an obvious inconsistent statement that is deficient for counsel in an ID case to ask about?
That could potentially be deficient.
Well, has it not? What constitutionally allowed counsel not to ask that?
There was nothing that didn't allow him to not ask that. He looked at Mr. Lucas's overall statements. The fact that Mr. Lucas initially indicated that he did not see anything, we don't know the reasons why he said that. Mr. Lucas never testified at the evidentiary hearing.
I understand that. What strategic reason would allow counsel not to do something that is obvious that any counsel would do in an ID case?
Mr. Shea testified that his focus was to minimize any statements that brought out the execution style of the...
But this doesn't go to
right.
that. I agree.
But again, Mr. Lucas did not testify at the evidentiary hearing, so we don't know what possible reason he could have had for initially telling police. I don't know. It's entirely possible that he didn't see anything. It's also possible that he had a mistrust of police and did not want to be involved initially.
That's all possibly true, but none of that is supported by the record. What is
correct.
supported by the
It would be
record?
speculation.
What is supported by the record is that there was an inconsistent statement, and I guess my question is, wouldn't constitutionally under the Sixth Amendment, isn't someone entitled to have in an ID case to be cross-examined on an inconsistent statement regarding ID that did not increase the premeditation issue, deal with the beard issue that he was worried about, deal with cocaine use that he was worried about? None of that is implicated by that initial statement by Mr. Lucas. So what constitutional reason did he have? Now, prejudice might be separate, but I'm talking about on deficiency only.
I'm unaware of any reason why he would not have asked about that, because he wasn't confronted with that during the evidentiary hearing, so I don't know what Mr. Shea's reasons were specifically for not asking about why he didn't go into why Mr. Lucas initially stated, I didn't see anything, and then coming forward with very detailed description and then being consistent throughout his deposition and also his trial testimony. It would be pure speculation, and that's why it's the state's position that there would be no prejudice, which you need to succeed on Strickland. You need both deficient performance and prejudice.
Well, let's talk about some other areas then. So I want to talk about the failure to hire a forensic expert, and specifically with regard to a trajectory analysis or the analysis of the bullets. As I understand it, expert Robinson testified, based on his review of all the physical evidence, that there was a second shooter. Did he testify to that?
I don't remember if he did testify that there was a second shooter, but this would be inconsistent with all of the eyewitness testimony.
Wasn't there a bullet fragment that was some significant distance away, and also a bullet hole that was at the top of the car that was inconsistent with the other bullet holes that had gone through, that led Mr. Robinson to conclude that there was indeed a second shooter?
That would be pure speculation that there was. It would be inconsistent with the rest of the evidence that was presented at the trial through multiple eyewitnesses, that not one person testified that there was a second shooter, but it still also doesn't negate the fact that defendant was the shooter by his own admissions.
It certainly negates premeditation, and it certainly negates culpability, does it not?
Well, defense's expert at the evidentiary hearing did testify that based on his review of the evidence, based on his review of the reports and the photographs and everything else, that there would have had to been a break from the time that defendant was shooting from the driver's side and then moving around. The court found that based on this court's precedent, that was enough to establish premeditation. And defense's expert ultimately testified, the FDLE expert that was presented at trial. And
well, let me ask you this. If the expert had testified that there was a second shooter, would it have been constitutionally effective counsel to not have presented that evidence to the trial?
I think it would have been.
Why?
Because of defendant's own admissions that he was in fact the shooter.
Well, that's not negated by there being a second shooter.
A second shooter doesn't negate the identification. It doesn't negate the premeditation. It just it's a potential of someone else being involved. It doesn't negate all of the other evidence implicating the defendant as the one who shot at the victim. And again, I believe that a jury would have rejected a theory of a second shooter given the extensive testimony from Ms. Burns, from Ms. Hart, from Mr. Beatty, from Mr. McCrimmager, who all testified to only seeing one shooter. Now, regarding Ms. Burns, opposing counsel brought up the fact that she knew Mr. Martin in the community because he had tried to, in her words, holler at her, and that she was not interested because he was a known coke user. Mr. Shea testified that he did not think that was an appropriate issue to go into because, one, having a witness who did in fact know who the shooter was and know his identity bolsters that identification versus a jury hearing that I had never seen him before, this is the first time I saw him. That is more unreliable than someone who knew him for several months or several years, and such is the case with Ms. Tashiana Hart. Ms. Hart testified that she did not know him before. However, her mother testified at the evidentiary hearing that's not true. I was the one who introduced them. It was shortly after he got out of prison for a previous murder. And this was 2 years that he was originally released on that murder charge. So Ms. Hart would have known him for a very substantial amount of time. Now, as far as calling 2 additional witnesses, Mr. Jones and Mr. McGowan, Mr. Jones initially described the shooter as a short, fat black male, then proceeded to change his story and said it was someone who was about 5'10", 160 pounds, and then changed his story again and testified it was a short, fat black male, as Mr. Shea testified when he spoke to him. Ultimately, in his own affidavit, he admitted that he would be unable to identify the shooter. The same with Mr. McGowan. His statements were that he did not see the shooter, he would not be able to identify. This would not be helpful to the defense. It would not be helpful to the state either. They didn't see anything. They did not see, Mr. McGowan did not see the shooting. And then Mr. Jones would be cumulative to what other witnesses had already testified to, that they saw someone shooting from the driver's side, moving around the car and continuing to shoot the victim.
Mr. Jones, though, was given a photo identification and was not able to identify Mr. Martin, correct?
Correct.
Why not ask Detective, is it Chizik?
Chizik, I believe.
Detective Chizik about that?
Mr. Shea testified that his strategy and his concerns with talking to him about that, because Mr. McGowan testified that it looked like him but couldn't identify him.
I'm talking about Mr. Jones.
Oh, sorry. He described the short, fat guy, which matches the defendant's description.
I know, but he was specifically shown the defendant's picture and was unable to identify him. How does that not help an identification defense?
Well, because the defendant had actually changed his appearance between the time of the murder and when he was arrested a few days later.
But how does that how does the failure to show the ID implicate that? How would that, and I understand the strategic decision to avoid that, but how does asking Detective Chizik if Mr. Jones was able to ID him or not ID him implicate that issue?
I don't think it would. I think.
So then how is it a strategic decision to avoid asking that question then?
Well, it wouldn't help, and it would not help the defendant's case.
It wouldn't help that someone who was on scene was not able to identify the
Because-
defendant when shown the picture?
Because it would ultimately come out that the defendant had changed his appearance, that he had shaved.
But I guess that's what I'm asking is how would it have implicated that? But just asking Detective Shizik if Mr. Jones was shown a lineup and was unable to identify Mr. Martin.
It would, I believe that they would have gone into questions about, well, isn't it true that the defendant was clean shaven when he was arrested on November 2nd of 2009, just a few days after, and Ms. Hart's testimony that he had in fact shaved a few days later when she came in contact with him. So I believe with all the other evidence that came out from Ms. Hart and from other witnesses, including Mr. Lucas describing him as having a beard, and other witnesses describing seeing facial hair, I believe that would have been implicated for the jury that it looks like him, but I don't think it's him because there's a substantial change to his face. And he would not be able to identify him with that change. And that was Mr. Shea's concern. There was also a question about why not investigate Mr. Frazier, who was involved in the shooting a few days prior to, who was involved in a shooting involved with Franklin Beatty, who Mr. Frazier had also been shot. Mr. Manti, the prosecutor on the case, actually confirmed that alibi that Mr. Frazier, after being released from the hospital a few days prior to the murder, was immediately sent down to South Florida so that he could recover from his injuries and was not, in fact, in town at the time of the murder. And so there was no evidence presented to contradict that alibi, so Mr. Manti's representation said he did confirm that alibi, then that's why Mr. Shea did not go down that road of asking about Mr. Frazier. Now, in terms of calling additional witnesses, opposing counsel presented the testimony of Mr. Davis at the evidentiary hearing, and he ultimately told people that I did not see anything on the day of the murder, and he also testified that he did not see the shooting and he did not see who the shooter was. His testimony would not have been helpful whatsoever to defense because he didn't actually see the murder. If there are no further questions.
Can you, before you sit down, can you address for me the jurisdictional argument that you make in your brief?
Yes. The state is arguing that because there is a final order vacating the death sentence that has now, this case is no longer a death sentence. It is the state's position that this court should not have exercised jurisdiction over the case, and it should be determined whether or not this case will continue to be a death penalty case before the appeal is heard.
Are we permitted, or is any court permitted, forget us, any court, permitted to hear an appeal of the guilt phase claims separate and apart from the sentencing that's currently pending?
The federal courts under, and I did cite it in the jurisdictional section of my brief, in Berman v. United States, the United States Supreme Court held that the judgment is the sentence, that you need to keep everything together, both the conviction and the sentence, to go through the courts, and that when you separate them, you're creating all sorts of problems.
Well, that may be true, but that's maybe an administrative decision made by the federal courts. Have we said anything like that, or is there any law that we've said like that where separating the two causes a jurisdictional defect?
Not that I'm aware. I do know that under Farina v. State, which I can supplement to this court did look into whether or not they would be able to have jurisdiction over a case such as in this situation where there was a order vacating the death sentence. However, this case is distinguishable from Farina because the state did not appeal the granting of Hearst v. State relief from the lower court.
Isn't, and I may butcher the rule, but isn't it 9.140, at least in a regular criminal case, a defendant is allowed to take an appeal from a conviction first and then can separately seek an appeal from the sentence. Is that, do I read that rule right, or do I not read that rule right?
I'm not sure, Your
Okay.
Honor. I do know that in a lot of those cases, because this court has exclusive jurisdiction over death cases and the district courts have the jurisdiction over the rest of the non-capital cases, that is where we get into a little bit of muddiness.
I agree with that.
So if there are no further questions, I would be relying on my briefs. Thank you.
I know I have just about a minute left, but I need to clarify some.
Almost two.
Okay, some very important misstatements of facts that I heard just a moment ago. So Willie McGowan did see the shooter. He testified, or he told police initially that he saw him, he saw his face, he could identify him again. Police showed him not one but two lineups, both containing Mr. Martin, one with Mr. Martin clean shaven and one with some facial hair. In both of them, he pointed to Mr. Martin and said, that looks like him, but it's not him.
Didn't the shooter also shoot at Mr. McGowan?
That's correct.
McGowan is the one that drove the victim to the scene.
No, he was the passenger. He was the passenger, and yes, he did tell police
And he was
that.
running towards the victim supposedly, and that's when the shooter shot at him.
Yes, that's what he told police.
4 times?
No, I thought it was just once.
Yeah, so he ran away. So why would Mr. Shea want to bring that out by calling Mr. McGowan?
Because McGowan would have said, yes, the shooter shot at me, but it wasn't Mr. Martin. I think that's why it would have been important to bring that testimony out.
Didn't he describe Mr. Martin basically to a short guy, heavy set?
Yes.
That fit Mr. Martin's description?
Well, I think the important thing is that he said he looked at his face. And then when he looked at the two separate photo lineups of Mr. Martin with different types of facial hair, he said, that looks like him, but that's not him. So I think that would have been important for the jury to hear.
But there was a strategic reason for not calling him. It was, as Justice Lavarga said, he being shot at, but there were two other aspects of it too. Didn't Mr. McGowan testify that Mr. Martin was the one, or the shooter was the one who told him where the drug hole was, where to go buy marijuana, and counsel wanted to avoid the drug issue?
Counsel did want to avoid the drug issue, but I don't think there was any mention from him about that specific thing.
And didn't Mr. McGowan have a very detailed description of the shooter going around to the other side, shooting in the passenger side?
He did. He did.
Didn't they want to avoid the premeditation issue?
That is what trial counsel said as his post hoc rationalization at the evidentiary hearing. If you go back and you look at the trial, the only defense that he told the jury that he was pursuing was misidentification. That's what he told them at opening, and that should have been his focus. How the shooting occurred should not have been as important as the fact that it wasn't Mr. Martin that was the shooter. And so that's why he was not reasonable in doing that. And just to clarify one more thing.
You need to tie it up in about 30 seconds. You're
Yes,
over
Judge,
time
I'm making
now.
it very quick. Mr. Jones was never shown a photo lineup. He was only spoken to by one detective the day of the crime, and he was never shown a photo lineup. And so I am just about out of time, so I would ask this court grant relief and remand for a new trial for Mr. Martin. Thank you so much.
Thank you. We thank you both for your arguments. The court is now in recess.
All rise.